Welcome everyone to this Privacy Espresso. Today I'm joined by Gabriel Avigdor, that is co-founder of the Swiss law firm Datalex. Gabriel is also one of the founding members of Privacy Group, so there's one more reason for me to be really pleased to be with him today. And Gabriel, first of all, welcome. And today we are going to discuss. Thanks. Today we are going to discuss about what's happening on privacy in general. This is a world that is changing every day, making it even more difficult to be compliant with for experts like you. So I would like to start with the first question, asking you, what's going on with privacy today?
So that's a great pleasure to be here again, Alessandro, as always. Thanks for letting me lead this espresso today. I think what we see is an increase in the legislation and more regulation, more and more. We have been seeing a lot of enforcement difficulties to harmonize privacy because of enforcement, because of data transfer issues, because some localization efforts. I think this is something that we see and that is a bit contrary to what the GDPR or what privacy laws are seeking. Because, for example, if you take the GDPR, it was meant to be a harmonized law, which essentially has more than 70 or 77 opening clauses, and we face a lot of inconsistencies. Let's say what I'm observing is a tension between seeking for harmonization and localization, which is something that is going to be interesting to see how it evolves. That's what I'm observing. Obviously, we can say that with 20 and 21, we've been seeking also for, due to COVID, with harmonization of rules also, because it's impossible to have local rules everywhere different, right? So this is maybe a first response to that question.
Yes, perfect, Gabriel. Thank you very much. And do you have any practical example of what you were saying and that can also express the difficulty of what's happening?
Yes. So I think there are a few examples. I won't, because we are talking about data privacy especially. I think there is one difficulty that we face with health data. If you think of clinical trials, or if you think of the use of health data of patients, I think there is a huge misconception, and there is a huge difficulty to navigate with which legal basis you use for health data. I think maybe we can talk a little bit about consent. Consent is, I think, and I'm observing, one of the most misunderstood concepts, I think, from a data privacy, European data privacy law perspective, also because of the law and because the GDPR is a law that is prohibiting processing activity unless it's permitted. I think it's interesting to see, for example, because I'm a Swiss qualified lawyer, that in Switzerland we've been taking the other way around. We've been taking the way of saying it is permitted unless it is prohibited, and that's very important because then it allows a lot more. Let's take the example of conducting research and clinical trials. There is health data that a sponsor of a clinical trial may have and may collect as a controller to conduct clinical research. The problem is that with health data in the GDPR especially, there are deviations that you need to use, and there are exceptions that you use, and you can conduct research without consent. Most of the time when you conduct research, there are ethics committees, and there are health authorities, and there are data protection authorities. So you have, and there are sponsors and hospitals, and all those players have different views. And if you want to take again this harmonization versus localization or decentralization, this is a massive issue for clinical research, because what if you conduct a clinical trial in multiple countries to do research? When you have one form that is not using consent, it's a notice, but then you see you need consent here and not there, and here and not there. There is it's extremely difficult for multinational companies to navigate with that, and this is a huge difficulty. So with health data, you also see that some initiatives, for example, when you conduct personalized medicine, you want to put on the market a personalized medicine, and you have to collect health data. You need to have a legal basis, but you can have exceptions under Article 9 under the GDPR, which says when you have sensitive personal data, you need to have an exception. One of the things, and then you come back also to clinical trials, is that consent does not work. Why? Because it's not freely given. If you say the treatment or the clinical trial participation is subject to your consent, because if then you say, well, you have the option to say no before or after, you deny the treatment, you deny the participation, which is a detriment, which then the consent is not freely given. So this is where, with health data, there's a massive difficulty to navigate. And there's a clear misunderstanding about how to use how and when to use consent. I think another example to go out of health data is WhatsApp. WhatsApp has been bundling terms and conditions and data privacy notice, a privacy notice saying, yeah, you have to agree to that to continue, but it also relates to personal data, and they've been going back and forth. And now you see that an easy task to try to harmonize something within regions and to do something consistently in one single way is extremely difficult, because they just missed this opportunity to say, hey, we just want to be more transparent. What happened is that they lost the trust of many customers just because of that. So I think there's this tension between, we would like to harmonize and to make something and to use the opportunity of privacy laws that says almost the same in the principles. You need to have a legal basis, you need to be transparent, you need to have proper security measures, you need to transfer that data securely in a consistent manner to protect EU rights, etc. But then you face what you've seen, because you did not properly do that. So other examples that we can find, cookies, I don't want to go into a discussion, but there's a huge tension, and there are solutions, but it is really difficult to navigate with that.
Yeah, you are opening a Pandora box, I think, or maybe more than one. But in terms of what you're saying, that was really interesting, Gabriel. Are there some ways to solve those problems, or an approach that you would take in order to at least trying to navigate in these difficult times?
So I think there are obviously solutions. It depends on the resources that you have and the time that you can spend. And also it is perfectly advisable, and it's perfectly doable actually, to harmonize and to seek for having a global approach that tackles many laws. It essentially, privacy is all about OECD principles, right? We have 7 or 8 OECD principles that says you have purpose limitation, you have data retention, you have transparency, etc. And based on this, almost any law around the world is saying similar things, right? So if you base your approach saying the privacy principles and the granularity of information is about meeting those principles, you can make happen a lot of things consistently and globally, or in many regions, without having to go locally in each market to have one specific form.
Perfect, Gabriel. Thank you very much. And I can feel a kind of proposal of an ethical approach to privacy. Go beyond just your regulation. Try to really understand what are the core concepts that are shared in different regulation in different countries, and apply them. Because if you apply and comply with them, probably you will be not complying with all the rules, but probably on the right side to start being compliant with many of them. Definitely a very good advice. So this is the end of the recorded part, because we end up of our 10 minutes recorded time. So thank you for joining us, and see you possibly next week, next Thursday, with another expert. So thanks again, and bye everyone.
Thank you very much.